At a time when authoritarian leaders across Africa are looking to scrap the two-term limits imposed by their respective constitutions, the case of Dr. Danny Pule and three others versus the Attorney General and Davies Mwila in 2018 has catapulted Zambia to the forefront of term limit controversies. The case highlights one of the many constitutional legal gaps in Zambia's 2016 constitution. The Constitutional Court asserted that President Edgar Lungu did not complete a full term of office as defined by Article 106 when he was elected in 2015, and that the relevant provisions in defining term of office should be read holistically. Now, the outcome of this process is therefore that Lungu has been deemed eligible to run for election in the next presidential elections in August 2021. However, this judgment seems to contradict the two-term limitation imposed by the 2016 Zambian Constitution, Article 106.3. Well, to discuss this issue further, we now have invited Dr. Simutanyi to unpack this controversy for us. Thanks very much indeed for joining us, and welcome to the program.
Thank you very much, Peter, and thank you for having me.
All right, so this sounds like something that happened in Nigeria, if I remember correctly, where we have a head of state who passes away and then somebody takes over. And then the question becomes, is that a term or not a term? Is this where this issue begins?
Yes, it's now very complicated because we have a structure called the Constitutional Court, and the Constitutional Court was asked by Danny Pule and others to make an interpretation in a hypothetical case. At the time, they did not necessarily, the name of Edgar Lungu was not mentioned, but they just made a hypothetical case. But everyone knew it had to do with President Lungu. And they relied on Article 106. And if you read Article 106 clearly, I'm not a lawyer, I'm a political scientist. But if you read Article 106 clearly, it does not relate to any other person but a vice president who would have contested the elections as a running mate, and then there is a vacancy in the presidency, and that person would then, if they had not completed if there was the time remaining was only less than 5 years or 3 years, then they would be deemed not to have been served a full term. That particular provision don't apply to a president who leaves office. It applies to a vice president. But for some reason, the Constitutional Court uses that particular provision. But in our case, in the case of the two-term provision in the Constitution as it stands today, it says any person who has twice served as president is not eligible. Twice served as president means the person contested elections 2 times and was sworn in as president 2 times. So it says, it doesn't talk about a person who was served a term, but who actually became president 2 times. So I think you are aware also that the Electoral Commission of Zambia unilaterally removed one of the provisions on an affidavit. There was an affidavit for all presidential candidates to swear that they have not served as president 2 times. That I swear that I have not been elected president twice. That provision meant it was to conform with Article 106. So that article talks about a person who has, you can only serve can only be elected twice.
Right.
Now, in our case, I'm talking as a political scientist and not as a lawyer. In our case, we have a scenario where President Lungu was elected in 2015 under an old constitution.
Right.
In that provision, when he was elected first, he was deemed to have served a term of office. Because under the old constitution in which he was elected, that term that he concluded, which was only 18 months, it stood for a full term. So when he contested in 2016, it was a second term, because he was elected and then sworn in. So it becomes a term. But for some reason that...
so the duration of the term didn't matter. The fact that he was
elected twice, that's all. But of course, you know, we are in Africa. The Constitutional Court has pronounced itself just yesterday, I think it was that day, that on Friday, that as far as they're concerned, this matter is now closed. President Lungu is eligible, and I think he's eligible because of the law. The court is the final court. There's no appeal to it. So that's where we are. And in my view, I think the only way to deal with this now is politically. It cannot be dealt legally. Constitutionally, it cannot be dealt. It is really a waste of time. So the opposition parties and others who feel that is not eligible, I think should use the election, the campaign process to bring out this issue. So if they don't want him to continue, I don't think it's necessary anymore to continue talking about it, because both the Constitutional Court and of course the ruling part, they're adamant that he stands again, and I think that's going to happen. So he has already filed his nomination, has paid his nomination fees, and we don't expect the Electoral Commission to pronounce on it. Of course, there are plans to petition that.
Yeah.
Yes, go ahead.
Are we saying then that a precedent has been set for the future if this happens again? Or is this just an anomaly at this time because we were straddling an old and a new constitution?
Yes, it's an anomaly. You know, we had an opportunity to correct the anomaly. I don't know if you heard about an initiative to change the law, which came to be called Bill 10. A bill was brought to try to harmonize some controversies or some controversial provisions or unclear provisions that were in the 2016 Constitution. Unfortunately for the government, they brought in different things. They brought in, instead of trying to clarify the same issue, there's an issue of handing over power to the Speaker, which was controversial because the President did not actually do that in 2016, and many other areas that were unclear and vague. It was expected that those things would have been clarified and made much clearer and so forth. But instead, what government tried to do was to remove some of these provisions altogether. So there was opposition to that bill, and it failed. In that bill, there was even an effort to remove this kind of thing altogether, but it didn't work out. But of course, as it turned out, the Constitutional Court has obliged. You know, it was constitutional. you have a court which is packed by loyalists. So really,
all right. So let's be clear then. Let's assume that President Lungu becomes president, and his running mate is alongside him. President Lungu serves only 3 years of his term. The deputy president, in theory, takes over as president for the balance of the 2 years. Will that in future be counted as a term or not?
Yes. Now the way the Article 106 is phrased, if a vice president takes over when it's less than 3 years, that vice president would not have served a term.
That's the current constitution now.
That's how it is. Yeah. So in an event, he doesn't complete 3 years. He doesn't complete a full term, and what remains is less than 3 years. Then the person who takes over the vice president will be eligible for 2 full terms.
Okay.
That's how it is. Yeah. So okay. There's no problem. I think the problem is that in his case, he did not take over as a running mate.
Yes, that's right.
He took over, in a different kind of.
All right.
So this is why there was this debate. But I think the debate is closed now. I don't think that the only thing that we know, this is what African leaders do. They find ways to extend their term, and in this case, President Lungu and his party have actually more or less succeeded in extending his term. It happened in Namibia. Sam Nyoma also said, the first term would not count because he was not elected universally. Yes. So.
All right, Dr. Simutanyi, we're going to have to leave it there. Thank you so much indeed for joining us and clearing up this issue that's being debated. And it looks as if President Lungu will get a chance to serve a 3rd term in office in Zambia.